Yes. This is the final assignment for Sherrod J. Glenn Sr., Trinity Law School, MLS660, which is property. October the 12th, Professor Michael Parker is the teacher. This is Landlord, Tenant Law. Basically, the landlord-tenant relationship is defined by the existence of basically leasehold estates. At one point, the only obligation of the landlord in the United States was to grant the estate to the tenant. However, it's been clear that a landlord must put a tenant into actual possession. Now, the landlord relationship has been based mostly on the outlook of these leases and include many elements of contract law. It says in American tenant law, many of these rights has been instilled in what is called the residential landlord-tenant law. Now, there are four tenancies. We're going to get into a lot of depth. Basically, there's tenancy for years, periodic tenancy, tenancy at will, and tenancy at suffering. Okay. Tenancy of years, of course, is known is your basic rental contract. Basically, it has a beginning date and it has an end date, and both are determined beforehand. I said duration, it could be a week, could be 2 years, could be a couple of years, and it varies based upon agreement. Now, this is a long contract is one that needs to be month to month. A long contract or one that turns out to be month to month is considered to be a periodic tenancy, and you'll find that the tenancy for years is actually the most common. Okay. Also, periodic tenancy is commonly seen when a rental contract continues past its termination date and is not renewed. So basically all the same dates. Basically, the end of your contract or your regular rental contract, when you're going through a situation where you haven't renewed anything, this is called periodic tenancy. Okay. A tenancy is made orally and will be measured by how rent is paid. Most likely after your rental term, it's normally month to month. Notice must be given to terminate, and the period of notice depends on the frequency of rent paid. The only exception is if it's a year to year, then you have to give at least 6 months. Now, tenancy at will has no fixed period and lasts as long as either tenant or landlord desires, and basically it's the occupation of the property until such time as the landlord gives notice of the tenancy. I say tenancy at will is created by an agreement between the tenant and the landlord, and but it cannot be transferred. Okay, you cannot decide to lease it out or something like that. Tenancy at sufferance is basically the end of the contract where the tenant is no longer paying any rent, and therefore it vacates when it stops when the landlord demands the person to vacate. Basically, this person is deemed a tenant in sufferance. Okay. Now, as a tenant, you have certain rights. Many people actually don't know their rights. As much as a rental contract looks like it's geared towards the landlord, there are certain things that you have right to and also that you're required to do. First off, you have a duty to repair. That means, in other words, to keep the property in reasonably good repair as much as you moved in. Okay. You can upgrade if you want to, but notice that you have to get the landlord's permission. Otherwise, you could be deemed as committing waste. You cannot commit waste, neglect, or destruction of property. Mind you, there are some separate criminal laws that deal with that. You have a right, or excuse me, you have a duty to pay the rent. Please don't go to someplace and believe that once you get in, you don't have to pay any rent. It's required. Okay, and failure to do so will get you evicted. As a tenant, you cannot be locked out of your residence for failure to pay. Years ago, there were too many times where people would think that they could just simply come into your house and toss you out. It's not the case. Okay, you cannot be forcibly removed or moved out without due process of law, and that means going to court. And so you have the right to the quiet enjoyment of your residence, and that means your landlord cannot harass you in your home. If the landlord breaches the covenant, he can be sued for what they call constructive eviction. Now, with the constructive, there are three elements that you have to prove. Basically, the landlord must substantially interfere with the use and enjoyment of your residence, basically stopping you from enjoying it the way you would like to. I said, and then you must give notice of the problems, and the landlord must fail to act within a reasonable time of the notice. Basically, if the landlord cuts off your water, you tell the landlord, or there's a water leak and it's constantly leaking, and you tell the landlord about it, and the landlord does nothing to do with it, then at that point you consider that to be an interference. And then you must vacate the premises within a reasonable time if the landlord does not fail to correct the problem. You can, of course, sue him at that point. You should be responsible for all damage. If you cause damage to the property, and most landlords will require a security deposit, and they'll deduct from the security deposit, but you are responsible for any damage, defacement, or removal of property inside the property. Okay. Now, there is an exception, of course, if that damage or defacement was due to the landlord or the landlord's agent or somebody he hired, or something he supplied, then or the landlord or the acts of invitees of the tenant or natural forces, then of course you're not responsible. Okay. Now, the landlord has rights as well. He's got a duty and he's got some rights. Most rental contracts are written to affirm those rights. Okay. Now, the landlord has a right to expect payment of rent for the premises on time. I can't stress that enough. On time. You also have they have a duty to keep your property habitable. That means the ability to offer electric, plumbing, heating, ventilation, and other facilities. Okay. If you don't have something, you need to make sure that it's there. Okay. You have a duty to satisfy the implied covenant of quiet enjoyment. Okay. The landlord cannot come over your house, cannot bother you so much as so that you can't enjoy your place of residence. Okay. As talked about in previously, you cannot interfere with the use and enjoyment of that residence. Okay. Also, the landlord has a duty to maintain the property. Okay. Meaning he has to repair the property for basic human habitability. And if he does not, then the tenant has remedies. Remedies includes an opportunity to move out, what they call repair and deduct. Many states allow a situation where if item needs to be repaired, the tenant can turn around and get someone to repair it and then pay that person and deduct that money from the rent. The person can also reduce the rent in terms of when he sees something that's wrong, he can determine exactly how much the value of the property is without that thing being fixed, and then give that money. Now, first, I must admit that you must give the landlord an opportunity to make the repairs. You cannot just decide you want to do all this. You have to give him an opportunity to repair it. Okay. Now, the last thing is remain. The tenant can remain in possession of the property and sue the landlord for the damage. Okay. The landlord must not commit any act of retaliatory eviction. And that means basically you cannot come in and do things, call the health inspector, or try and forcibly remove that tenant. Okay, please note that there may be additional duties or responsibilities per your state. And see, I can only give you North Carolina general statutes. Okay. Now, the landlord is required to provide operable smoke detectors, either battery operated or electrical. Okay. And he's supposed to ensure that it's operable and in good repair at the beginning of each tenancy. The same thing goes for a carbon monoxide detector. He is either battery operated or electrical, and he has to ensure that it's operable. Now, the landlord cannot discriminate against you in renting to a tenant based on race or religion, national origin, familial status, or age, disability, marital status, sexual orientation, or source of income. There's many kinds of discrimination and that are outlined in actual federal, state, and local laws. Now, there's certain misconceptions in renting, and we have to discuss them. And sometimes you'll run into one or two of them. I do not know, but it's best to always contact legal advice. Now, first off, the landlord is under no obligation to repaint the premises. I don't care how long you've been staying at a place, he's not obligated. The law never mandates for cosmetic changes. Now, if the landlord doesn't spruce up from time, and then what will happen is that he won't be able to find or keep tenants. Now, the landlord is also not required to change the drapes or the carpets. Doesn't matter if they're stained or anything like that, as long as it's not creating a health hazard. Tenant is responsible for fixing or paying for a broken window that either they or a guest intentionally or carelessly break. Now, the exception to that is, of course, a burglar, a vandal, or a neighborhood child who throws maybe a baseball or something through the window. The landlord is usually responsible for that repair, and may get the money from someplace else. Okay. Landlords are not legally responsible to change the locks in for new tenants or provide heavy-duty doors or windows or locks. However, if you feel for your safety, you have to inform the landlord, and if he does nothing, and should someone break in and attack you with an old key, the chances of the landlord being held liable in a lawsuit go up. Now, lots of tenants are absolutely convinced that if rent is due on the 1st, they have until the 5th of the month to pay, or even longer, because they are within a legal grace period. Sorry, but that's not true. Okay, your rent is legally, and I say legally due on the date specified on your contract. If a tenant is subject to eviction and eventually goes to court, even if they catch up their rent by paying all the fees, they can be subject to eviction or can be evicted later on without having to go back to court. Okay. Landlords believe that they are not responsible for tenants' injury. However, they can be found negligent for most tenants' injuries if they are either directly or indirectly responsible. They could be negligent, for example, a handrail that's defective on a property causing a fall. That gives them credence for negligence and can leave them liable for a lawsuit. Now, landlords believe they can do a lot of things that may be considered illegal. For example, they cannot hit a tenant during an argument. Doesn't matter if anything's going on, you cannot have a fisticuffs. And that's considered to be an intentional action and can be criminally tried. There may be emotional or physical injuries such as sexual harassment, landlord trying to get sex instead of rent, assault, even if it's non-physical, such as him threatening you or menacing you, and repeated invasions of privacy, where you unauthorized entries into the tenant's living space. I remember a story, a story on TV that was called Good Times, where the landlord, whose name was Bookman, would constantly come into the tenant's apartment without their permission. So that in itself would be a crime. The tenants and landlords believe that if you tell one another about a complaint or an issue, that it's binding by law. It isn't. Write everything down and present it. Give time to correct it. And if not corrected, there are other remedies. Now, here are some laws that govern the state of North Carolina landlord and tenant relationships. General Statutes 42-1 to 42-14.2 is Article 1 of that tenant and landlord provision. General Statutes 42-25.6 to 42-76, that's a long one, which is Article 2A through 7 of the landlord and tenant provision. Now, they give the basis for the rules of any situation in renting in North Carolina. Now, General Statute 42-46 shows that it governs late fees and evictions fees. There may be other fees that are associated, which are talked about in the statute. However, there is no reference to a grace period. And I talked about that before. I said, although it indicates that a late fee can be applied after 5 days, but there is no grace period. If someone wants to evict you for not paying the rent on time, they can. There's no grace period. Statute 42-14 indicates that the amount of notice on a tenancy such as month to month is only 7 days. Week to week is only 2 days. There's no state statute on the amount of time required to change the rent or other items. So that means the landlord can change the rent. If he wants 1 month, he can change it, and the very next month he can change it again. All right. North Carolina has no state law that deals with rent withholding or repair and deduct, something you would need legal advice in reference to. It also has no state law that deals with reasons that a landlord may enter your dwelling. Most landlords can enter to deal with emergencies, to inspect the premises, to make necessary repairs, alterations, or improvements, and then also to show property to prospective tenants or purchasers, and during a tenant's extended absence. Now, General Statute 42-37.1 deals with prohibiting the landlord retaliation and gives 12 months as a baseline for from a tenant's complaint to the landlord or government agency, tenant's involvement in tenants association, or the tenant exercising their legal rights. Now, if he does something in between that, you can of course get do a grievance or something to that effect. Now, there are many laws that protect both the landlord and the tenant. If you don't know, consult an attorney and do some research. There's more than enough information out there. I just touched on a few. Now, here's my reference page that I got the information from, and I thank you very much. I enjoyed this class, and I hope to see you or hope to see some of my fellow students in the near future.